Right, Mr. Pathan, I hope you've been in touch with your father over lunchtime.
He's not speaking to me. The embarrassment, my incoherence is now disowned. Right. Can I just start with trying to answer the questions some of the questions that were asked before? My lady, you were asking about applications, so I've now got instructions, hopefully with some clarity. So the answer is, if you're going to, if a person's going to make an application to a new Tier 2 sponsor, or on some other basis, the application form, a new application form has to be filled in for that application to be made. And if the application fee for whichever type of new application he's making exceeds the original one he's paid, he has to pay the difference. But because of the wording of 3C2, 4 and 5, you know, the extending leave, because 3C24 says you can't make a fresh application whilst you've got 3C leave. 3C25 says but you can vary the existing application. And so the Secretary's approach is to treat new applications made during 3C leave as a variation of the original application in order for 3C leave to continue.
Thank you. So for our purposes, it's a variation. You can do something.
Yes.
With the information.
Yes. Well, yes, you can do something with the information, just as you could do something with the information. You could choose to leave before.
Yes, but something which has a direct impact on the application, because you wouldn't a new one substituted for the old.
Well, my lady, I mean, the Secretary of State's position is that it doesn't impact on the merits of the existing application. It gives you an alternative to avoid your existing application failing.
Correct, but the old application is academic.
Well, it would be once you've made the fresh application, but in effect, therefore, what you're inviting the Secretary of State to do is to not apply the rules to the existing application, which would result in it failing, and saying, well, can I have time to make another application? And can I have some leave whilst I make that other application?
Thank you.
The other point, and this was my Lord Kerr, I just wanted to be sure that I hadn't inadvertently confused matters in terms of revocation of the sponsor's license, because I'd refer to a period of 20 days. That 20-day period, just in case it was inaccurate, 28-day period occurs prior to the revocation decision. So it's not a 20-day grace period after the revocation decision. So, so the sponsor's told, these are the reasons we're going to revoke unless you...
Yes.
Yep.
And can you challenge a revocation?
Can the sponsor?
Yeah.
There's no appeal against the revocation.
Judicial review.
Yes.
Thank you.
So, going back to where we say we are at the moment, is that essentially the appellant's case is that because he wasn't unaware of the information, or because he was ambushed, as he says, and in relation to the information, and it wasn't his fault, it's unfair for him not to be given another go. And we say, actually, articulated in that way, this is a classic argument of substantive unfairness, whether it's irrational in those circumstances not to grant him further leave, having regards to his legitimate expectation, the reasons for the unfortunate situation he finds himself in, the interests at stake, and the nature of the PBS system. And all of these matters, we say, influence the decision in Taupada. And can I ask you to turn up Taupada, which is in Volume 1, tab 23, and I'm going to be asking you to go to MS 930.
Yes.
So, if you look at paragraph 33, you can see that the appellant relies on the principle of substantive fairness. If you could go back a page, or 2 pages, to 927, you can see that there's common law fairness, failure to give notice at paragraph 21. And then at paragraph 31, there's also substantive fairness. And in terms of the judgments, we've been through the sort of facts of the case. Can we start with Lady Justice Hallett's judgment? So she starts off at the top, 36, looking at the context by reference to Mandalia of the system and the fact that there are harsh outcomes, hard-edged decisions, but with the view of promoting efficiency, transparency, and objectivity. And then in 38, she deals with the position and the reason why it failed. And it's quite correct to say, or to refer to the fact, that it's the sponsor who makes the mistake, who didn't take the utmost care. But the point we would emphasise is 4 lines from the bottom of that paragraph. There's a sentence that starts, "There was no point." And in contacting the appellant, to give him the opportunity to make representations, the only solution would have been for him to make yet another application if his immigration status permitted. In this case, it did not, because by this time he'd become an overstayer. To my mind, that's not the fault of the system, and there was no unfairness. And if you could then turn over to the next page, 931, and read paragraph 40, there's a reference there by Lady Justice Hallett to being nothing unfair in the PBS system that requires applicants to comply with the requirements of the rules. And if there is a fundamental error of the kind here, for the Secretary of State to refuse the application without giving notice, particularly when generally another application in proper form can be made. And that, we say, is very much the position here, because another application in the proper form can be made. If you then turn to page 933 and we have a look at Lord Justice Underhill's reasoning, you can see it, paragraph 52, in contrast to this case. I found the second sentence acknowledges that there is no doubt that the Home Office made an administrative error. And then a few lines further down, Lord Justice Underhill says, the Secretary of State thus created the opportunity for the error in that application that led it also being rejected. It's not difficult to see how it could, in those circumstances, be described as unfair for her to rely on that error. Then he goes on to say, though, the crucial point is that both the rules and the published guidance to sponsors make it clear that a cause reference number can only be used once. The point we make is that the rules and the guidance make it absolutely clear that if you don't have a valid cause, your application fails. So there's equal clarity as to the basis and reason for which the application in Taupada failed and the application in this case failed. If you go a few sentences... Can
I just pause you there? Could the problem in that case, and I'm not sure I've 100% got my head around it, but I will in due course, have been cured by what is sometimes described as a new application and sometimes described as a variation of the type which you mentioned to us at 2 o'clock?
Yes.
It could have been.
It could have been. Using Lady Justice Hallett's analysis, I mean, in this case, the sponsor, I think, supported the appeal, saying, no, I made the mistake. So there'd been no difficulty at all in the sponsor actually giving the right cause or not withdrawing the cause, I can't remember which one this is, and that being the basis for another application. Yep, which would have, I mean, if all the other criteria were successful, were met, that would have succeeded. If we can just go back to paragraph 52 in Lord Justice Underhill's judgment, 5 lines from the bottom, there's a sentence that starts, in those circumstances, I cannot regard the rejection of the second application as substantively unfair. It might be different if Miss Yar had made it clear to Miss Warshott that she was intending to reuse the number from a previous rejected cause and had been told in terms, and this is by the Secretary of State, that it was all right to do so, or even perhaps had not been told that it was not. So Lord Justice Underhill there is considering, in the context of substantive unfairness, the situation where the Secretary of State might have contributed to the situation where, or the reason why an application was refused. And so in terms of the points that were made on a number of occasions to me before lunch, which is, well, yes, it might be the sponsor who failed to comply with his obligations, but in fact, the Secretary did then take a decision. You can see that in the context of the Secretary of State's actions having an impact on the application process, that's been considered by Lord Justice, or the potential, is being considered by Lord Justice Underhill as a question of substantive unfairness.
But Mr. Biggs isn't challenging any of the point-based system rules at all. He's simply saying, you should have told me about this in March rather than June. How can that be other than procedural, a procedural complaint?
Because, my Lord, if we had told him in March by way of notifying him that his application had been refused, so on the same day we revoked the licence, the sponsor, we tell those employed by him that either their leave is curtailed, or if there's an outstanding application, it's failed. That, my understanding is, that Mr. Biggs does not accept that would be a fair procedure. He says that not only do we have to notify the appellants, we have to then give them a period of time
To respond. But if you could respond...
It's not really the period...
Not to respond, to enlarge.
Or actually, we say not to respond, we say to look for something which is completely different from the outstanding application. But, my Lord,
yet the completely different thing appears to be capable of being described as a variation, in the sense that if the Secretary of State said, look, your sponsor has been struck off, we'll give you 60 days to see if you can find another sponsor. As I understand it, if you did find another sponsor, you can introduce that new sponsor by a process which, although it involves filling in a new form, is treated for its effect on your immigration status as if it was a variation.
That's correct if it's made in time. So yes, within
but why isn't that a response that effectively saves the day? In other words, why isn't it within the concept of procedural fairness that requires a major fact? I'm thinking of Lord Justice Floyd's example, which you rely on, which makes an application which could be remade good by a variation to be made good by a variation. Why isn't that procedural?
Well, we say that it's not procedural because whilst it's referred to as a variation, it is in fact a new application. It's a new form, it's a new... So, for example, you wouldn't be in the position where the work that's been undertaken in relation to the first application contributes to the new application. Whatever new application is made, you start afresh.
Well, except that the 3C, is it 3C, leave... Continues.
Absolutely. Yes.
And as I understand it, it continues on Home Office analysis because it's treated as if it was a variation.
Yes, that's correct. But it's also...
But you say it's a variation but not a variation.
No, what I'm saying, though, is that for the context of procedural fairness, it isn't... That option isn't, we would say, a response in the sense of procedural fairness to the information and to addressing the merits of the outstanding application. Instead, it is simply provides an option for avoiding the entire sort of original application process. When you look at the cases such as Cooper and those line of cases, the individual is being provided with the information in order to respond to that information in the context of the outstanding application. He isn't being notified of the fact that an application is bound to fail or a decision is bound to be taken, so that he can take a step that unrelated to the merits of his original application and just make a completely new application or deal with a completely new issue. I mean, certainly that's the Secretary of State's case. Yeah? The Secretary of State's case is that this isn't an issue of procedural fairness because the appellant isn't asking for the opportunity to address the merits of the outstanding application to cure the defect caused by the fact there's no cause, because that, you can't cure that. Yeah? And the fact that you can make another application, Secretary of State's position is that even if it is a procedural fairness point, it's completely inconsistent with the way that the points-based system is intended to operate.
Does your case set out the materials which underlie the way in which the 3C leave is extended, where you get a new cause?
It does. And
Whereabouts is it? Because this is a variation, 3C5 is a variation of a variation application. And I'd like to know what the substantive law is that gives you the power to make the variation application in the first place.
So, my lady, if you go to Volume 1, Tab 2, you've probably gone there already, my lady, MS 369, that sets out the criteria of 3C.
369.
Oh, yes. My lady, yes.
Are we talking... What am I going to find when I get there?
Hopefully you will find 3C, section 3C.
Oh, sorry, I was looking at it in the
Just remind me, what's it a section of?
judgment.
It's 1971, the Immigration Act 1971. Have you got
What, the Act?
So it's not 3C, is it?
My lady, my lord, if you go to 368, you will see that it says 3C.
Yes. And it's in the judgment as well of the Court of Appeal, isn't it?
Oh, yeah.
That's where I was looking at it.
Yes.
Continuation of leave pending variation.
But it doesn't tell me how the person comes to be a person who has limited leave to enter or remain and is applying to the Secretary of State for variation. Is there any other provision, or do we just assume from that you can apply for variation of such a leave?
Well, my lady, it's common ground that Mr. Pathan had limited leave. He had to, and what he was doing was applying. I mean, this application was an application to vary that leave, to extend it.
But what tells me you can make an application to vary a leave?
Sorry to interrupt. May I assist, my lords and my ladies, to look at tab 2 of the Supplemental Authorities Bundle, where you'll see paragraph 34BB of the immigration rules.
What's the MS number, Mr. Biggs?
I'm sorry, it's in the Supplemental Authorities.
Yes, I know. Yeah.
It's electronic page 5, internal page, hard copy page 5, 2, behind tab 2. That's the relevant immigration rule dealing with variations.
Which paragraph?
Multiple applications.
Yes.
34BB.
I'm so sorry, could you give me the page number? The electronic.
Page 5 of the electronic.
Electronic 5,
page
thank you.
Behind tab 2.
But this isn't telling me, in many areas of the law, your entitlement to make an application for variation would come from the legislation or the rule. Paragraph 2.
Oh, you say, my lady, I'm so sorry. If you go back to the bundle I took you to, so volume 1, and you go to page 14, I hope this...
Page what?
Sorry, big one, page 3, MS 363.
Yep.
Well, let's, for convenience sake, let's actually start at 362. So you have general provisions for regulation and control. You should have a heading at page 362, MS 362. Yes. And then you can see one C refers to the fact that someone who isn't a British citizen needs to be given limited leave to enter in order to enter. And then paragraph 2 and 3 are the critical ones. So 2 deals with the and gives the power to create the immigration laws. And then...
I'm sorry, but this will help you.
Yeah, it's 3, isn't it?
And then 3, yep, against that it gives the power.
Yeah.
So, with a slight tinge of embarrassment, that I hope is the answer.
Yeah, yes, that's...
Well, if it satisfies Lady Black, that's...
It looks as if it's the answer.
That's an achievement.
I mean, the variation being described in section 3C 3, is that where we're on?
3C, my lord.
Oh.
Before we 3C.
3C. Page?
My lord, sorry, it's 369, MS 369.
Oh, hold on, I'm on the wrong page. Right.
Whilst you're looking at that, Lady Black, there's another, perhaps even more information, an MS 372, and under the heading Administration Control, sub-paragraph 1, you have the reference or the basis upon which the Secretary of State and the caseworkers can exercise that power.
Right.
And then back, if you don't mind, to 369. You have the reference to, I think we've been to 3C4 and 5, and the reason why the fresh application is referred to as a variation is in order to ensure that the leave continues.
So it's a sort of deemed variation, but you say not deemed a variation for the purposes of procedural fairness.
No, so really the contrast that we draw is between giving someone a chance to rectify or to answer the criticisms that or the flaws in the outstanding application, which we would accept that is something which relates or gives results to procedural fairness, and giving someone an opportunity to make a fresh application, even if it's referred to as a variation of the original one. Because the fresh application simply, or the opportunity to make the fresh application, is simply a result of the fact that the first application is going to fail.
You'd have to have inside knowledge to know that it was going to be deemed to be a variation, would you? Because it's a variation of a variation application.
Yeah.
Yes, to be honest, the person making the application would just have to make a fresh application, and then it would be the caseworkers that in order to,
So they're giving a benefit to the applicant, basically, but you wouldn't get it out of the legislation or the rules.
But I'd have to accept that it is common knowledge, or certainly in terms of legal advisors, that if you make a further application whilst your application is outstanding, that will effectively bring to an end your original application, and it will only be the fresh application that's assessed. So you'd never have two applications being decided at the same time.
But in the context where what you've lost is your sponsor, the fresh application would have all the same material as the original application, except there would be a new sponsorship number.
No, well, with respect, my lord, no.
It's not as simple as that.
No, because obviously you'd have to comply with all the requirements and establish that you're, in relation to a completely new sponsor.
Right.
Huh? I mean,
I just haven't.
No, big point. No,
so
I didn't mean.
Or the variation might be a human rights point.
Absolutely, which should be completely different.
Yeah.
Yes.
So, the discretionary leave point.
No.
My lord, I didn't mean to sound impatient. It was just panic that the view was being taken that you simply just changed a cause or something. That I'm sure my clients would be furious if that was left right. So, and then obviously, well, in Taupadi, can I leave it to you then to read Lord Justice Singh's analysis of it?
Is that the first place where we find this distinction between procedural and substantive being developed?
In categoric terms, my lady, given it a big one, I think I ought to go to it because it is the basis, of, an important basis, isn't it, of the judgment actually in Pathan. And Lord Justice Singh, on the back of, I think his judgments in Citizen UK and Kebble, where he's obviously focused a great deal on summarising and reviewing the case law on procedural fairness and substantive fairness. If you turn to page MS 934,
What is this?
My Lord, this is Talpardo again.
Oh, very well.
I beg your pardon. And the reason I ought really to go back to it is that it is obviously heavily relied on by Lord Justice Singh in the Pathan decision.
Yes.
So,
But this does seem to be the root of this distinction.
my Lady, yes.
Yeah.
And so when paragraph 56 is where he really draws this emphasis between and the importance of distinguishing procedural fairness and substantive fairness. And then at 57, he summarises the principles in terms of procedural fairness, which he's also done in greater length in Citizens UK, and as he says, they're Keble developments. And he focuses, we say correctly, very much on the concept of hear the other side, which is the reference 4 or 5 lines down in paragraph 57. And then at 58, he makes the point I've been trying to make, that this is nothing about hearing the other side, it's about giving the other side a chance to make a fresh application, which is why he says, and we say correctly, that this isn't a matter of procedural fairness, this is a matter of substantive fairness. And the points that have been put to me in terms of the potential unfairness of the Secretary of State knowing something or having taken a decision that wasn't communicated or hasn't given an opportunity, we're not saying those aren't matters that shouldn't be considered or aren't capable of being considered, but we say it's in the context of substantive, not procedural fairness. One other point which is worth two other points which are worth looking at is Lord Justice Singh at 59 considers substantive fairness, and obviously after this judgment is handed down, you have the judgment in Gallagher, which we will go to. And of course, Gallagher does change the position in terms of substantive fairness. And it actually endorses and goes beyond what Lord Justice Singh says in terms of the limited scope for any substantive, legitimate sort of expectation arguments. And Lord Justice Singh's position is really it's paragraph 61, and as you'll see when we look at Gallagher, the Supreme Court go beyond that. May I just draw your attention to paragraphs 63 and 65, because they are very important aspects, we would say, and really underlie the importance of keeping procedural and substantive fairness apart, because as Lord Justice Singh makes clear in 63, substantive fairness, it has to be kept within defined and predictable boundaries. When he builds and explains this point in paragraph 65, 4 lines down, there's a sentence that's, well, it's 2 lines down. He acknowledges the doctrine of substantive fairness as an important tool. And then in the next sentence he said, however, that doctrine should not give the court a wide-ranging discretion to overturn the decision of a public authority which it considers to be unfair. This is not only because of the risk of blurring the important dividing line between the function of the court and the function of the executive, it is also because the doctrines according to which a court will interfere with decisions of the executive be set out reasonably clear, predictable form, so that everyone can know their affairs.
These are important points, but they're also fairly obvious points, aren't they?
My Lord, yes. And I will avoid taking you to further obvious points. Really, my Lord, I was doing that really just to try and emphasise
I know you were.
the perspective from the Secretary of State's position. Can I just say one point which may be hopefully slightly less obvious? If we could turn back to MS 933, it's a point that's made by Lord Justice Underhill and echoed in a case called UK Ivory Coast, which we will go to. It's the bottom sentence at 933, where he says, but the issue is not whether the outcome is hard on him, but whether the Secretary has acted unfairly. And from that point of view, it is not appropriate to distinguish between him and his sponsor. And we say that that's an important point, because it is the sponsor in this case who has let down the appellant by not complying with the regulations. Can we then turn to Patel? Now, there's been little attempt to actually justify the decision in Patel. And we say with good reason, because Patel, which is found at tab 25, and it starts at MS 946, but I will be referring you to, well, I'll start at 951 and paragraph 9, which highlights the fact that which highlights the fact that the appeal wasn't actually contested by the Secretary of State. And then if you could turn to 953, please.
Yes.
You have if we go through paragraph 20, the point is made that a refusal to leave is a serious step, very serious step. And then the third sentence, which starts, although we accept that such a person is free to make a subsequent application for leave, that application cannot by definition comply with the immigration rules, since the application has no leave to remain. Now that is wrong. Yep. The application can succeed, as long as it's made within 28 days back then. Well, no, it's still 28 days, isn't it? Yeah. So that was
Which sentence was that?
My lady, it's 5 lines from the top of paragraph 20. It's on the right-hand side of the page. It starts, although we accept that such a person is, so in other words, someone who's been refused, is free to make a subsequent application for leave, that application cannot, by definition, comply with the immigration rules, since the applicant has no leave to remain.
So if he used 3C5, he could make an application?
Well, what the tribunal was saying is that if he were a person to make an application after his outstanding application was refused, it couldn't succeed.
Because 3C would no longer be available?
That's right, because effectively because he has no leave to remain.
But you say that's wrong?
That's wrong, yeah, because he can make an application within 28 days,
Yes.
and that's common ground, and it wouldn't be refused by reason of the absence of leave.
I mean, we're writing down 28 days and thinking, oh, well, then that's reasonable enough. But I suspect if we knew more about what a new application required, we might be saying 28 days is a perfectly hopeless period in which to get one's act together to that extent.
Well, my lord, you might be, but the reality is that the system provides for that period. And
do I make an application when I post it to you, or when you see fit to stamp it as being received?
No, you do it online. That would be the common way to do it.
How long does it take to get your new sponsor certificate number?
Well, it depends. I mean, if you were to know, I mean, obviously you have to find an employer, but if you find an employer who's taken the necessary steps to be in a position to support or to sponsor a Tier 2 applicant, then you would he would fill in the sponsor form. He would fill in that number because he would have been given it, and the application could be made immediately.
And does he have a sort of single number that's used for every employee, or is it a separate number each time?
My understanding is it's a separate number for every cause. So effectively, once you're sponsored and you've taken the necessary steps, you're given a cause number, which you would then assign. You have to do it within 3 months of the sponsor within receiving it, and it's really the sponsor that inserts that number, not the applicant.
And the sponsor can just open a drawer and get it?
Yes, I mean, they have it electronically,
yeah.
And it depends on the sponsor in terms of how they keep it. But, for example, if you wanted to make a leave, a different application, discretionary leave to remain, then you can, I mean, you don't need a particular amount of time to make the application. You make the application, you say, I've been here 7 years or whatever you need, and then obviously you then have time once you've made the application to put in the evidence and support. But there's no reason, my lord, to answer your question, that you couldn't do that within 28 days.
Yeah, but if you wanted legal advice, which you might well want, finding a solicitor who will take this case, he giving you the advice, and then you implementing it, I should think that's probably totally unrealistic, Mr. Payne.
Well, my lord, perhaps it's perhaps you might be overly pessimistic. I mean,
Okay.
the purpose of the PBS system, and I'm well aware of your comments in terms of your concerns about the system which you quashed in Mandalia.
Yeah.
The system is intended to operate in a sort of very automatic system,
Indeed.
which is meant to be relatively straightforward. So if you're going to make an application, you look at the form, and you're meant to be able to just tick or insert the relevant data. And obviously, in terms of the sort of evidence you might need in support, you can submit that, after the application. But it should be relatively. I mean, the whole goal of the system is to make it relatively.
Okay, thank you very much. You said we were going to Gallagher, is that right?
My Lord, yes, I'm sorry. There were 3 more points I need to make in relation to Patel.
Oh.
Sorry to take your time, but if you then go to paragraph 22, because this is critical before we go to Gallagher, you can see that where the applicant is both innocent of a practice and that led to the sponsorship status and ignorant of the fact of such loss, it seems that the common law, fairness, and principles of treating applicants equally mean that each should have an equal opportunity to vary their application by affording them a reasonable time in which to find a substitute college. In the curtailment cases, the last sentence, express Home Office policy is to afford 60 days for such applications to be made. Now that's incorrect. In the curtailment cases, for those who have more than 60 days, the leave is reduced to 60 days. For those who have less than 60 days, it isn't increased. And so the most closely comparable person would be someone with very, very limited leave, 1 or 2 or 10 days, who wouldn't have his leave curtailed, reduced, but it wouldn't be increased. And so when you're looking at equal treatment, we say that the tribunal weren't actually comparing like with like. They were comparing, they misunderstood the policy, misapplied the policy, and in fact required, because they do require, you'll see it, well, if you just note down paragraph 32, they require the Secretary of State to give an applicant in these circumstances 60 days leave. In other words, they require the Secretary of State to put the applicant in a better position than someone with 59 days existing leave. And then when you look at paragraph 24, it says it's obviously unfair to revoke the college's status after the application and not afford him opportunity to vary an application. So we say that the analysis of fairness in this case is all based on equal treatment. That's the only reason that's given. And there's no other reason given for why it's obviously unfair, save for the fact that obviously unfair is the terminology, like conspicuously unfair, which was used prior to Gallagher to revoke substantive unfairness. Now, if we go to Gallagher...
But this is all very well, but the point about Patel is that it has become a policy to grant 60 days.
Well, my lady, for reasons that are unclear, Patel wasn't challenged. But the fact of the matter is that the decision to introduce the policy was by reference to what the court required at paragraph 32. And it was done in the context of students, where we say the objective and the underlying rationale for Tier 4 is very different to Tier 2. Because, and we've made the point in our written submissions, Tier 4 is about encouraging students to come to the United Kingdom to study. They are service users. So effectively consumers. They have paid for a product. And in those circumstances, if that product or the services they've acquired is taken away from them, you can understand that there is perhaps greater fairness requirements to let them finish it.
I understand that, but that may be going one deeper than the court needs to go, because what the court needs to find out, isn't it, is whether the grant of a 60-day application, or whatever it is, a 60-day window or lesser window, would bring the PBS system to its knees. And that patently isn't so for students.
No, my lady, and That's certainly correct. In terms of Tier 4, it hasn't. But my lady, it has been imposed on the Secretary of State as a requirement, and it's been imposed as a, we say, on an incorrect understanding of the existing policies, discretionary policies in terms of curtailment.
But the Secretary of State could have introduced legislation to reverse the effect of Patel.
They could have taken, I mean, that would be quite a significant step. But the reason for accepting the administrative burden that came with the court order was, as I tried to explain, the different considerations that apply to Tier 4, where it was felt that in the context of the benefit to society, benefit to UK-based students, giving the 60 days leave. Perhaps I can make the point slightly more eloquently by, if we just turn to if we take bundle 3 and we go to tab 75, you can see the very different objectives of the two systems, Tier 2 and Tier 4. Sorry, my lord. If you go to if you go to page
2224. 2224.
Well, my lord, I was going to just go to Tier 2 first, if you didn't mind, my lord. 2253. So this is how will Tier 2 work. And if you could read paragraphs 90, 91 and 92.
Yes.
Yep. And then if you turn over to the next, if you turn over to 2255, and you read 102 and 103, you can see because I'm going to contrast the concerns of those consulted, TUC, yep, with the potential impact on local workforces of allowing Tier 2 or excessive numbers of Tier 2 people to remain, which is why, as you see at 103, the undercutting the resident labour market, which is why you have the test, the residential test and the requirement for employers in the UK to first, for example, publish the job to make sure that there aren't local or settled workers that can undertake the jobs. Now, if we go to page 2259, you'll see the contrast between this sort of limited, this route which is limited to filling posts that can't be filled by the UK students, and if you should have on the left-hand column Tier 4 students, and then in bold you have the very significant financial benefit that is brought in, that they reflect. And then if you look at 126, you can see the far more relaxed approach to granting leave. Because there, the process from the outset provides for much greater sort of flexibility in terms of the leave granted even after the course finishes, for further steps to be taken, further courses to be maybe and applications, if necessary, for change the leave in terms of work. Now that is, we would invite you to contrast that approach, which is the more students there are, the greater the benefit, and reflected by the flexibility in terms of students changing courses, with the very different approach to Tier 2, which envisages a far more limited grant of leave.
I should alert you to the fact that you have 3 minutes left, Mr. Payne.
My Lord, I thought, did I have 2? Oh, my Lord.
You indented for 2 hours, and 2 hours will elapse in 3 minutes hence.
My Lord, yes. Can I then very quickly, I think, my Lord, with your leave, can I be allowed a quarter of an hour to wind up my submissions?
Well, let's settle for 10 minutes, shall we?
My Lord, yes. I'll be procedurally fair. My Lord, you've got
Been able to make your application and it's been considered anyway.
Well, I've been given notice. I can accept that, and I've had a chance to make my representations. So, could I ask you very quickly to turn to Gallagher, which is at Volume 1, tab 16, and can you turn to Volume 1 of the Authorities, MS 735? Can I just ask you then, actually, due to the time, just to mark up the paragraphs. If you look at paragraphs 19 and 20, just as a point of reference, is that actually, quite unusually, both parties before the Supreme Court were actually in agreement that the public law requirements and fairness and equal treatment existed, and there was a sort of freestanding right, and that's the same terminology as was used by Mr. Justice Blake and Patel. But then if you go to paragraph 24, and perhaps just mark them, you will see that despite that agreement, the court held that there wasn't such a principle. And if you could mark on page 737, if you could mark the passages between B and D, and then if you could turn to page 389, and if you could mark the passages between E and H. And then if you could turn to MS 741 and mark the passage between D and F. One more page, please. MS 743. If you could mark the passage between F and H. And in essence, the Supreme Court held there wasn't a freestanding principle of sort of equal treatment in terms of providing a freestanding remedy. It was an aspect of fairness, and substantive fairness really added nothing to the ordinary Wednesbury approach. And we say, as did Lord Justice Singh in Pathan, that totally undermines the analysis in Patel. And so whilst my own friend makes the point that other Court of Appeal cases or judgments haven't questioned Patel, that those judgments were before the judgment in Gallagher, and now when you look applying Gallagher, we say that there can be no doubt that the analysis in Patel was incorrect, and therefore it cannot and should not form a basis for concluding that the issue in this case really relates to procedural fairness. Now, can I turn next to the case of, the statement of Mr. Richard Jackson, and that's in the core volume, and it starts at page MS 272, and I invite you to read the entire statement, but I'm just going to deal with this point which my learned friend raised in terms of paragraph 19, and you've been taken to 19, which is page MS 277. But you need to understand what this paragraph relates to. It relates to curtailment in the 60-day provision. And you need to read it in light of what follows, which is paragraph 20. And you can see that certainly from the Secretary of State's perspective, these are the reasons why curtailment, which involves reducing an existing right, isn't applicable, or the same considerations aren't applicable to someone who doesn't have leave and with an outstanding application has no expectation of being granted leave. Really set out at 20 to 22. My lady, you also indicated, and you asked me about sort of the difficulties, the fact that Patel didn't sort of bring everything to a grinding halt. You will also, when you read Mr. Jackson's statement, you will see that difficulties did arise in relation to something called the Patel cycle, cause difficulties.
Thank you.
And this is followed by a statement by Francis Buzio, which is starts at MS285, and we'd invite you to read that statement. Now, in terms of procedural fairness, two cases, my Lord, and then those are my submissions. A case that's rather surprisingly hasn't been challenged is EK Eritrea, and that judgment is at tab 18, volume 1, and I'm really going to commend to your attention the analysis of Lord Justice Sales.
On page.
My Lord, it starts at MS 798.
Thank you.
Did you say Eritrea?
No, big one. I did. I meant to say Ivory Coast.
Very well.
Ah.
And this was a case where the appellant was raising not only the right to have notice, so that they could make another application. You can see that from paragraph 4. I won't ask you to turn it up, but also to find another college. But the analysis of the Court of Appeal focuses solely on the right to notice and find another college. And really, my lords and ladies, I will really invite you to read the entire judgment of Lord Justice Sales, which really considers the issue of procedural fairness in the context of the PBS system. And the really significant paragraphs, if we could perhaps go through them, paragraph 28, which summarises the intention of the system or the goal of the system, and 31, which acknowledges that the PBS regime is supplemented by the procedural fairness, and then the paragraph 33, where Lord Justice Sales says that having to effectively give an applicant notice so that they can explain the error would be inconsistent with the smooth running of the PBS system. And something which we would ask you to bear in mind is that an important issue, which was considered by all the judges in EK Eritrea was the fact that actually there was a mistake. Yeah? And so the issue was, let's check whether it was a mistake or not. And that's why the appellant in that case was saying, well, I could have told you. Here, in fact, there isn't a mistake. Yeah? It's a correct decision. So in contrast to EK Eritrea, where it could be said that the appellant was sort of denied an opportunity to explain the mistake, here there was no need to. And then paragraphs 36, 37, 38 at MS 801 refer to the wider issues which point against a requirement to notify and give a period of leave in terms of the factors beyond the system, but just really focusing on the impact. And paragraph 40 refers to the significance of the system, PBS system, running as intended. And then I won't take you through my Lord Justice Briggs's judgment, which starts at 54. We also would commend the analysis in that judgment. But what I would say, just very quickly, is if you look at Lord Justice Floyd's judgment and look quickly at paragraph 50 and 51, we would say that a fundamental sort of misunderstanding of the analysis in those paragraphs is that the PBS system doesn't run on the basis of an assessment of fault. Yeah? The PBS system is meant to run on the basis that you either have a CAS or you don't, and if you don't have a CAS, that's the end of the application. So it removes discretion from caseworkers, and so the idea that people should be given a chance to explain whether it's a mistake, we say, is inconsistent with the PBS system. And turning very quickly to Balajigari, which is in tab 19, the very next tab, and you can see that this is a totally different case where it involves applications for people who've been in the UK for 10 years and applying for indefinite leave to remain. And it's 9 years, 5 years. Thank you. And if you turn to page MS822, and just mark paragraphs 42 and 43, which runs over to MS823. So it's MS822, paragraph 42, and 43. You will see that the important point in this case was that what was being alleged was dishonesty, which is a very sort of serious allegation, and that in the context of dishonesty there is obviously a discretion. And so it was in that context where if you turn to MS825, and you could just mark paragraph 50, in which the Court of Appeal considered the case of Fayed, but the important paragraphs, just for purpose of my oral submissions, are 51 and 52. And that is what's critical to the judgment in Balajigari, which is two things. One, it's a very serious application that goes beyond the mere application of the criteria. And two, it involves a discretion. So the applicant can change the outcome of the existing application by explaining the discrepancies which cause the Secretary of State to doubt his honesty. One final point in terms, or two final points in terms of Balajigari. Balajigari didn't, as you can see, proceed on the basis that every application under Tier 2 needed to be given notice. It proceeded on the basis that this was an exceptional category where there was discretion, and it was distinguishable from the categories where there was the mandatory application of the rules. Now, just very quickly in terms of in terms of Article 8, we say it adds nothing to the common law, and that's indeed, in terms of procedure, that's what the court held in Balajigari at paragraph 93. And Balajigari, as I said, was an application for indefinite leave to remain, and they hadn't raised, they hadn't in this case, Article 8. And what the court said in Balajigari, if you want to raise Article 8, and if you turn to page MS835, there's someone who's made an application under the rules who then decides they want to raise Article 8. They don't say you're entitled to vary the application. They say the procedural requirements, paragraph 98, are that you make a fresh application paying the right fees in compliance with the rules. So that just really hammers home the point that no one's been denied the right to make the application or the opportunity. It's simply a question of leave. Oh, my junior just mentions one point. Quark, which my learned friend relies on a great deal. In fact, if you read it, if you read it carefully, it is all about the opportunity to make representations, being denied the opportunity to make representations in terms of the application that's being made. It went from 4 to 2 ships, some of the criteria changed, and what the court held was that should have been, the applicant should have been informed about that so that they could have adjusted the representations they made in the context of the application to meet those new criteria. So it wasn't a case, as is suggested by my learned friend, of being able to make a completely new application. It was just standard points that the criteria changed and they needed to be told about the criteria or the reduction in number of licenses so they could adjust the submissions they made to answer those difficulties. My lords and ladies, thank you very much for your patience. Is there anything else?
Not at all. Well done, Mr. Lane.
Thank you.
Mr. Harland? Thank you very much indeed. Mr. Biggs?
Very grateful, my lord. Just a few points then, just to deal with a couple of points of clarification or to set out a dispute between the parties on something that my friend said. Firstly, we don't accept that if an invalid COS number is entered into an application, then the application will reject that attempt. So there's no validation process that prevents a Tier 2 sponsor or a Tier 2 applicant inputting an incorrect COS number, an invalid COS number, nor do we accept that an application will be invalid merely because an incorrect COS number is entered. As I understand it, what the validity requirements require is that all mandatory fields within an application are completed, so that if you enter an incorrect or invalid COS number, the application will be technically valid, although it falls to be refused on its merits. And in my respectful submission, my lords and my ladies, that's exactly what happened in Talpada, because in Talpada, the decision that was challenged was not a decision that the application was invalid, but a decision that it failed to be refused on its merits. Secondly, on clarification, we respectfully submit that it's just wrong to say that there's no discretion under the points-based system, because the points-based system operates at the level of immigration rules and policy, and it's axiomatic that immigration rules and policy cannot fetter the Secretary of State's broad discretion under the statutory scheme, in particular under Section 4.1 of the 1971 Immigration Act. And that's a point that's made in the Munir case, which I took you to in my principal submissions at para 44. It's also, of course, recognised by my Lord Wilson's judgment at para 31 in the Mendalia case, by reference to the well-established principle against a fetter of discretion. There the issue was whether policy could be so rigid that it fetters discretion in the context of immigration decision-making, held that it couldn't be, applying orthodox principles. Further point of clarification, it's wrong to say, in my respectful submission, that the appellant is arguing that he has an entitlement to make a variation application. That is part of the argument. We accept that because it follows from our argument about procedural fairness, but we just want to emphasise that it's not just a variation that the appellant could have pursued. He could have done, in my submission, 3 things. Some of them involve a 7 things. Some of them involve a variation, some of them don't. So first thing he could have done is he could have varied his application to rely on a new sponsor. Second thing he could have done is he could have varied his application to rely on a new entitlement under the immigration rules he thought he had. Third thing he
Such as?
Nothing in this case, my lord. I'm talking in principle.
Oh, I see.
I'm so sorry. But in principle, because of course this case involves a point of general public importance, that's available. So he could have, in principle, said that he had a new entitlement under the rules. He could also have raised human rights considerations by way of a variation application. He could even have asked for the Secretary of State to exercise her residual discretion, irrespective of human rights considerations, perhaps by reference to a policy about exceptional circumstances or whatever. And the 2 points that don't involve a variation are that he could simply have written to the Secretary of State and made representations without a formal application and made whatever points he wanted to. And in particular, finally, he could have asked for a delay to the resolution of the application so that he had time to set his and his family's affairs in order before he was made an overstayer.
I think that makes 6 rather than 7.
That's 6, is it? I'm so sorry.
That's all right.
Oh, you're quite right. Sorry, the
I
numbering,
once addressed the House of Lords saying that I had 7 points, and Lord Ackner's eyes ruled heavenwards and he said, can we settle for 5?
Well, can we settle for 6?
We can settle for 6.
So those are our points of clarification. Now, just 1 or 2 further matters. So we say that it's wrong to say that in reality what's being done here, what the appellant asked for is the possibility of making a fresh application, even assuming that the possibility of a variation is really the essence of his case, which, as I've explained, it isn't. The statutory scheme acknowledges that the making of a new application while the application for further leave to remain, that in this case was refused by the June 2016 decision, is outstanding, would operate as a variation. And that cannot be avoided by my learned friend's analysis, which appeals to substance, I think, instead of the position under the statutory scheme. And that's both because the statutory scheme is incompatible with my learned friend's appeal to substance, and it's also the position because the authorities, in particular JH Zimbabwe, have acknowledged that there is a very broad approach to be taken to the concept of a variation, and that's been the settled understanding of immigration practitioners ever since that decision. So the relevant passages are paragraphs 39 to 46. The cases behind tab 4 of the supplemental authorities bundle, pages 42 to 43, in both the electronic and hard copy for the relevant passages. So can we just very quickly turn that up?
Could you give me the reference again, please?
Of course. It's paragraphs 39 to 46, page 42 to 43.
I'm sorry, which page number?
Page 42 to 43. It's in the supplementary bundle, which is a separate electronic bundle. And it's behind tab 4. And just turning this up.
This is, I mean, I can't now remember what the issue was in JH Zimbabwe. Presumably it was whether some apparently further application amounted to a variation so as to trigger an extension of leave.
Exactly. I think there were two issues. One was, well, the essential issue was it a fresh application and therefore invalid because of Section 3C4, or was it in fact a variation and therefore valid by virtue of Section 3C5? And you can see at paragraph 39 to 40 that Lord Justice Richards, with whom the other members of the court agreed, reached the conclusion that a broad interpretation of the concept of variation of an application under the statutory scheme was appropriate. And he then applied that broad approach to find, as a matter of fact, at paragraphs 45 and 46, page 43, that even though a new application form had been submitted, there was, in fact, a variation. And so we say this approach appeals to substance in the right way. And so my learned friend is wrong to say that in reality, for the purposes of procedural fairness or otherwise, an application that operates as a variation is in fact a fresh application. By reference to this authority and with great respect to my learned friend, common sense, the statutory scheme. We also refer to paragraph 34, capital B of the immigration rules on this. It's behind tab 2 of the supplemental bundle, which we're already in, page 5, electronic and hard copy. We've
looked at this already, haven't we?
Looked at it briefly,
Yeah.
but the point I make about this is this doesn't just apply to a situation where there's an extension of leave under Section 3C. It applies across the board to all applications. So if you've got a pending application, even if you've made your application where you don't have leave, so there's no extension of leave under Section 3C, the immigration rules deem that to be a variation. And this, of course, because it's an immigration rule, sets out the Secretary of State's practice or policy in the context of the administration of immigration decision-making and discretion. And so that must be...
The effective deeming is what? Two things. Leave continues
where you've got
and no further fee. Is that right?
Not necessarily, no.
Oh.
But I'm appealing to this simply to make the point that the Secretary of State's own immigration rules recognises that making a new application while an application is pending operates as a variation.
Yes, quite.
I can't go beyond that.
No, okay. Thank you.
Next point we make is that my learned friend's criticisms of Patel do not undermine the core ratio of Patel insofar as it relied on procedural fairness. That is particularly clear when we bear in mind that the Thacker decision, which I've referred to in my principal submissions, preceded Patel and reached the same conclusion in terms of procedural fairness.
Lord Justice Floyd also referred to a case called Naved, which seems
That's
quite
right.
powerful.
We have that in the authorities
Yes, I
as
noted.
well. I'm sure, sorry, I don't have the reference to hand, but it's there too. And I've already made the point, since we're on Lord Justice Floyd's judgment, that Lord Justice Floyd's analysis is in no way inconsistent with the application of the Patel principle. The idea of a defect being irredeemable can't, in my submission, have been meant by Lord Justice Floyd in those passages that my learned friend relies upon to mean that a variation couldn't constitute a valid remedy, if you like. That would mean the Patel line of cases is wrong, and that's clearly not what Lord Justice Floyd thought. We also make the point that my learned friend is wrong to say that Patel has not, or to suggest that Patel has not been directly challenged by the Secretary of State in reported cases. It was directly challenged by Mr. Malik's submissions in the Raza case, and that challenge was rejected for reasons set out in Lord Justice Christopher Clark's judgment at paras 27 to 38, and I referred you to those passages earlier in my submissions. Penultimately, we respectfully submit that the case law my learned friend relies upon to make the argument that procedural fairness is only available to allow a fair hearing about the application of relevant criteria is nowhere near as restrictive as my learned friend asserts. And all I really need to say there is that the Cooper case is against my learned friend on this. As we point out at paragraph 51 of our case, MS 34, that's para 31 of our case, MS 34, Cooper was in fact a case where the builder was banged to rights under the statutory scheme in terms of the Board of Works' decision to demolish the property. And that's a point that is made in the leading academic textbook of Wade and Forsyth, which we quote in that passage in our case. We also make the point that Quark is probably, or may well at least be, a case too, where the application may well have failed on the application of new criteria. My learned friend, towards the end of his submissions, sought to sweep the Quark case aside on the basis that there had been a change in the relevant criteria from 4 ships to 2, and therefore the applicant Quark should have been given an opportunity to deal with those new criteria. But the reduction from 4 ships to 2 may well on the facts have meant that Quark's application was doomed to fail. And if one goes back to the analysis in the administrative court in Quark at 67 to 69 and the analysis of the Court of Appeal at paragraph 58 in particular, there's no suggestion that that sort of defect would mean that Quark wasn't entitled to procedurally fair decision-making. We also make the point that EK Ivory Coast is not a difficulty for us because it's a very different case. The central point in support of that submission is that EK was concerned a situation where the sponsor was responsible for the unfairness. It was the sponsor who withdrew a CAS, it wasn't the Secretary of State's doing that undermined the application. And this is a point that my Lord Briggs emphasised at paragraph 59 of EK at MS 805. Finally, we respectfully submit that it's simply no answer in this case to either the procedural fairness arguments or the substantive fairness arguments for my learned friend to say, well, an application could be made after a decision had been taken to refuse the September 2015 application in this case. There are 3 points that I want to emphasise in reply there. Firstly, by that stage, the harsh consequences for the appellant and his family had already crystallised. So when the decision had been taken to refuse the appellant's application, he was made an overstayer, exposed to the hostile environment, etc., and that's the real impact. That caused the real impact on the appellant. Well, it was all right. It was at a slightly later date, at the date of the administrative review decision, but in my submission, nothing really turns on that. Secondly, applying procedural fairness principles, which are trite, the appellant was entitled to notice in advance of a decision. He wasn't entitled to an opportunity to do something about the decision ex post facto. He is entitled to an opportunity to respond to the Secretary of State's concerns in advance. And finally, my learned friend is, with great respect, unrealistic to suggest that the appellant could have either put his affairs in order or made a new application within 28 days. And all I need to do to make that submission good in this case is just to point out that the resident labour market test that my learned friend relies upon takes 28 days to complete. That's clear from the policy documents we have in the bundle, in particular paragraph 28.18 of the policy behind tab 73, and that passage is at MS 2129.
I'm sorry, Mr. Biggs. What takes 28 days to complete?
The resident labour market test, my lord. So you may recall that my learned friend pointed out that one of the purposes of the Tier 2 regime is to
Yes.
make jobs available to migrants only where those jobs, the job market, the resident job market is not capable of filling those jobs.
Is that a test which the sponsor has to carry out before it can agree to sponsor somebody?
Yes.
Yeah.
So
Right.
it's probably worth just turning up that policy very
Is that
quickly.
before it can...
Yeah.
You don't have to do that for every individual who comes to you. You can have that in place as a general permission to take on an employee, can't you?
Yes. So the
I think
policy
that's what
sets
we were
out.
being told.
Yeah. The policy sets out the procedure, but what you
So
basically.
I think what we were being told by Mr. Payne was that if the employer had already got that, then it could be done quickly.
Well, that can't be right unless I've misunderstood, because if we look at the resident labour market test and the guidance setting out how to carry it out, which is behind tab 73, MS 2199, 2199.
Tab?
73, volume 3, my lord.
Okay.
So unless an exemption applies, which is a fairly narrow category, so where you're on where the job is on a shortage occupation list, for example, you don't need to carry out the resident labour market test, but in other cases you do. You have to advertise the vacancy for 28 days on the resident labour market in a specified way, and the migrant has to have gone through the application process and been selected, having gone up against in competition the resident labour market workforce.
So you can't do that before
Exactly.
38 days have elapsed.
Because we're talking about an employer who selects the migrant as the proposed employee.
Yeah.
So, unless I've misunderstood,
Well, it may be, we'll give Mr. Payne an opportunity to say something about that.
very well. But unless you have any further questions, my lords.
Thank you very
But
much
that also
indeed.
means that I think you need to correct the answer to my Lady Black, because you can't do the market test for a whole group of employees.
Oh, yes, absolutely. Because, I mean, we're talking about a particular employer selecting a particular migrant employee, then that migrant has to separately apply for and obtain leave to remain or further leave to remain as a Tier 2 migrant. So it has to be done in respect of every Tier 2 applicant.
Right.
Unless it's a shortage occupation,
Yes, I accept that, of course.
in which case you don't have to go down that road.
Exactly. But that's designed to be exceptional because the fundamental purpose or one of the fundamental purposes of the Tier 2 rules is to prioritise the resident labour market as a matter of policy. My lords, my ladies, unless you have any further.
Thank you very much. Mr. Payne.
I'm grateful. I think we disagree to the extent that the position that the Secretary's position is that were an applicant to find an employer that's undertaken in relation to various posts, the various steps like the residential labour test, he could sponsor immediately the applicant. So I'm not quite sure why there's a distinction there, because an employer doesn't have to wait until they've identified someone they would like to bring in and then carry out the test. They can carry out the test, and then once that's satisfied, as long as the applicant's got the relevant skills, they can apply.
But if they haven't carried out the test, they've got to carry out the test, and that takes 28 days.
My lord, yes.
Yeah, there's nothing between us, my lord, I think, my lord.
Good.
And just one more point, just to correct something which I think may be inaccurate, is that this appellant did make an application within 28 days. Yeah, so you, my lord, were saying, isn't it very difficult? It's at footnote 2 in my skeleton argument, but he did make the necessary application. It was
But it didn't prevail.
Well, no, because then what he did is he withdrew it later on, or no, he then issued another application and then another one. No, every time it avoids the previous one. But none of them have been successful, including the last one.
Well, thank you all very much. The command that Council who have addressed us of this complicated area of law is truly impressive, and I'm sure that's been supplemented by those who have assisted them. But it's given rise to a number of very interesting questions, which we will have to now tussle with. A very good, an old friend of mine said that the euphoria curve for council and judges is in directly converse position. You now relax, having completed your submissions. We now have to try to come up with the solution. So thank you very much indeed. The court is now adjourned.